Is there ever an instance where the doctor who I am questioning during a pretrial deposition will throw his hands up in the air and say, you know what, Mr. Oginski, you're absolutely right. I screwed up. How much should I pay your client right now? You want to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is, in now almost 36 years of practice, never. That never happens. You might be thinking, why not? If we have so much evidence against the doctor, if we have medical experts to say that the doctor departed from the standard of care, why wouldn't the doctor admit and take responsibility and acknowledge that he was careless and that his carelessness caused and contributed to your injuries? You want to know why? It's basically self-preservation. The doctor certainly does not want to admit and accept and acknowledge that he could ever do anything wrong. In fact, when we first start the lawsuit, you know what happens? The doctor's attorney serves an answer to the allegations. And in that answer, they basically say, hey, why are you suing me? I did nothing wrong. And if I did something wrong, so did you, Mr. Patient. Then they say, so it goes back to the question, why won't they go ahead and accept and acknowledge responsibility? I'll tell you why. If the doctor would have simply raised his hands in the middle of my questioning and say, you know what, Mr. Oginski, you're absolutely right. I was careless. I did depart from the standard of care. Now what they are saying is, okay, it means I am liable. I am responsible for anything that happened after that. I am responsible for your client's injuries. Now in law, if you are responsible for my client's injuries, now you have to get out your checkbook and you have to compensate my client for all of the harms and losses and damages that they incurred because of your carelessness. That's how it works. That's how our civil system of justice works. We can't get retribution. We can't go ahead and get revenge against the doctor. The only thing our system of justice allows us to obtain on behalf of my client, on behalf of our clients, is money as a form of compensation. We can't turn back the hands of time. We can't put things back to the way they were before this happened. So instead, the law says, okay, if we can show that the doctor departed from the standard of care and that that carelessness was a cause, doesn't have to be the cause, was a cause of my client's injuries, now the doctor is going to have to be accountable and responsible for all of the damages and harms and losses that my client suffered because of that wrongdoing. That's why the doctor will not voluntarily go ahead and admit that they did something wrong. That's why the doctor will refuse to acknowledge that he did anything wrong, that he violated the basic standards of medical care, that he departed from the standard of care, because the moment the doctor does that, this case would then shift from establishing liability, showing the doctor is responsible, and it would shift from showing that that wrongdoing was a cause of my client's injury, that's known as causation, and then the entire case would focus on damages. And in 99.99% of the time, this will not occur. The doctor will not accept responsibility until maybe the very end, or maybe not at all. And it ultimately will be up to a jury, if the doctor refuses to acknowledge he did anything wrong, about whether we are slightly more likely right than wrong. And if we are able to show that we are, then the jury will have to determine how much compensation my client is to receive, that you are to receive, as a result of that wrongdoing. So during this pretrial question and answer session, one of my goals is to ask the doctor not only what is the standard of care, or I should say what was the standard of care at the time, but whether or not failing to do A, B, and C, or going ahead and doing something led to a departure from the standard of care. After I have that information, I will then later on ask the doctor about this specific set of facts for which we are now talking about, involving my client. And then I will go through and ask him whether or not this represents the departure or a departure from the standard of care. And if it is, then I will go further and say, doctor, do you have an opinion with a reasonable degree of medical certainty as to whether that failure to do A, B, and C caused my client to suffer the following injuries? And the doctor is going to do everything possible to deny and deny and deny, as well as his attorney. And that's what they do from the very beginning, from the time that you start your lawsuit, typically all the way through up until and including trial. Now, are there instances where the doctor or his attorney will actually admit, yes, we recognize something was done wrong, we'd like to try and start negotiating? Does that happen? Yes, it does. For the most part, they tend not to do that. And if they do, it often will come very late in the litigation process, and sometimes it won't come until just before trial, where they recognize for the very first time, listen, it's not worth our while to take a risk and go to trial and have 6 members of the community render a decision, and we don't know, and you don't know what the outcome is going to be. So we'd like to manage that risk. We'd like to try and reduce or minimize that risk and see if we can settle or negotiate this case prior to a jury going ahead and evaluating this case. So why do I share this quick information with you? I share it with you because there are many times where a client believes in their heart of hearts that they know that something was done wrong. They know that their injuries would not have occurred unless this doctor was careless. So why do I share this quick information with you? I share it with you just to open your eyes to help you understand how these types of cases work in the state of New York. You know, I realize you're watching this video because you want to see the beautiful scenery. No. I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.